The federal judge overseeing former President Trump's election interference case setting a trial date for March 4th of next year. Now, the timing puts the trial directly in the middle of the Republican presidential primaries, with Super Tuesday slated for the very next day. Mark Levin is host of Life, Liberty, and Levin, and we've got this chart, Mark, that we can show everybody when these dates are. When we first heard the date of March 4th yesterday, I think people who are politically minded thought, isn't that right around Super Tuesday? Turns out, Mark, it's the day before.
So you're a federal judge and you're sitting there and you're saying to yourself, what date can I set that would not interfere with the election, that would allow the defendant to actually defend himself? And you pick March 4th, 6 months from now, in a case that involves 12 million documents, scores of witnesses, where he can't possibly have effective representation, and I'm sure there will be an appeal based on that, but you have to wait for the trial. But a couple of things. This judge not only set March 4th, Judge Chutkan, who, by the way, whose grandfather in Jamaica was actually a Marxist. This is in the New York Post today, and was imprisoned by the Jamaican government for a period of time. Chip off the old shoulder there. Anyway, there's something called the anti-suit injunction, and it's to deal with a situation like this. The Department of Justice under Biden and Jack Smith decided that they were going to bring essentially two federal cases so close to each other that Donald Trump wouldn't have the ability to defend himself. And they've moved for early trials in both cases. They moved for a January trial in D.C. They moved for a January-February trial, or maybe it was March, in Florida. You're talking about tens of millions of pages of documents and so forth. So they're piling on. They're trying to smother him. So if I would file a motion under the anti-suit injunction. The anti-suit injunction is for a case like this. When you have the Department of Justice, the Biden administration, piling on cases, piling on charges against a single defendant, and it's supposed to be tried within months of each other. The judge in Florida set the date for May. Now this judge in D.C. blowing off the judge in Florida. She should have waited in D.C. till the first trial was done and the first case was done if she had any desire to show due process rights to the defendant. But she jumped the other judge. That's the second case. So that's how important this issue is. It's bigger than even March 4th. So the motion should be filed with Judge Cannon in Florida, the first judge. And that motion should say, look, we can't have two trials at the same time overlapping each other with tens of millions of pages of document with a presidential candidate who cannot defend his liberty at the same time run for president. And the Department of Justice scheduled it this way intentionally. And the judge in D.C. jumped the line. She's the second case, not the first, in order to get her case before your case. And for whatever reason, that's what she did. So the Anti-Injunction Act would be Judge Cannon issuing an order against Jack Smith and the Department of Justice, telling them to cease the prosecution of the case in D.C. until the case in Florida is completed. Yeah. And that's the way it should be, because it's hard enough to defend against one case as opposed to two cases, or in Trump's case, 4 cases. Now, I want to mention also grand juries. Nobody has talked about this, to my amazement. The grand jury process is set up in the Fifth Amendment. It's in the Bill of Rights. You are to be indicted by a grand jury, not a prosecutor. Well, what happened when Jack Smith moved his charges from Washington, D.C. to Florida? He was in the wrong venue in violation of Department of Justice rules. But he gets his indictments, then he moves them to the grand jury in Florida. Now, the grand jury in Florida indicts. Okay. But a grand jury's indictment is not supposed to be a rubber stamp of something that happened in a grand jury in another jurisdiction. What exactly did that grand jury vote on? Did they ask for witnesses? Did they ask for any documents? I mean, this investigation in Washington has been going on 2.5 years. There's piles of information. And in 1 week's time, they indict the president in Florida on top of the indictment in D.C. I think that's fast and loose. I think Mr. Smith actually violated the grand jury rules in Florida. And again, I would file a motion of grand jury abuses, and I'd want to know exactly what they told that grand jury, because They're supposed to be truthful. They're supposed to present facts. They're supposed to explain the law. They're supposed to ask them if they want to talk to any witnesses, scrutinize any documents. I doubt that happened for the most part. And in Georgia,
Historically, though,
I'm just
Mark,
going to say
it's pretty
in Georgia
tough
they
to
have
get,
a huge problem.
It's tough to get grand jury, what they saw, what they heard, that interaction. Isn't it tough to get usually?
It's tough to be a defendant in any case when you're up against the government. All your motions are difficult to pursue. But this is unique. The circumstances are actually quite unbelievable. Why did he bring the indictments in Washington, D.C.? That's not supposed to happen when the material activities and events being charged occurred in Florida. So there's more basis for getting behind what took place in this case with grand jury abuses than there would be normally. That is, the government opened itself up. It doesn't have a good explanation for why it did that. None.
One more thing from me. Let me just ask you this, Mark.
Go right ahead.
This sets up for, it seems like, a lot of issues on appeal. But because these are happening real time during an election, is there a fast track process that somehow the appellate or the Supreme Court gets involved earlier?
The motion for the anti-suit injunction can be appealed if it's ruled against the president and the other co-defendants immediately, because it is a issue about the trial itself. So you can't go through the whole trial and then go back and say, and by the way, you should have issued an order to stop the other trial. Judge Chunkin in D.C. has pushed up the date to March 4th. So this is an immediate issue. It's a pre-trial issue, and it is an issue. We don't call this interlocutory appeal, but it can be immediately appealed to the circuit. In terms of the grand jury abuses, the Supreme Court has ruled you need to lay that out before a trial. If you lay it out during or after the trial, you have no basis for raising it at all. So you have to raise it now. So that provides a basis also for what we call an interlocutory appeal immediately to the circuit court if the president and the defendants don't get the result that they want. So both of these cases would go to appeal, if necessary, before the commencement of a full trial, to answer that question. And by the way, real quickly, I know we're out of time. In Georgia, when they posted the grand jury indictments, before the grand jury came to the courthouse, before they met, before they voted, and in Georgia, you don't have to use a grand jury, but when you do, you got to use it properly. That is a perfect case for grand jury abuse. And since in Georgia, there are no secrecy rules, as we know, it would be easy for defense counsel to find out what the hell took place in that grand jury. So these are things that can be done because there's no question that the Department of Justice has abused the law. They're piling on the charges. There's no question that the judge in D.C. is a partisan, one of the most radical judges in the federal bench of all the 1,000 district court judges. And there are ways to at least seek relief, even if they're tough. You don't roll over and play dead, because what the American people are seeing here is an abuse of the justice system, and judges, at least the judge in D.C., the judge in Manhattan, and we'll see about Georgia, are going along with it. In other words, they're allowing their courtrooms to be used to interfere with an election and to deny Trump and other defendants their due process rights. This is very, very important.
And we'll see what the Trump attorneys do after. I'm sure they're meeting. They got a lot on their plate, and it's a pleasure to have you on America's Newsroom. Thank you.
Thanks, Mark.
Thank you. God bless.
I'm Steve Doocy.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.